Well, good morning. This is Dustin Hobbs with the California MBA. Hope everyone is doing well this Thursday. Welcome to our Legal Issues Committee's regular quarterly webinar. This is our Q2 webinar for 2020. I want to welcome everyone. Before we get started, though, we're going to go over the agenda here in just a second and go over what we'll be covering in the webinar today. But I want to make sure and thank our two sponsoring firms, Hall Griffin and Klinedinst. As you all know, it's very difficult times right now for everyone economically, and we want to make sure and send a special thank you to both firms for their continued sponsorship of this committee. I know that everyone's going to get a lot of good content out of the session today. And if you take anything back with you that's actionable or useful for your company, make sure and send a thank you to Jared Eade at Hall Griffin or Ian Rambarran here at Klinedinst, and thank them for their sponsorship of this committee, because that's the only reason that we can make this happen and provide you with great content. So with that, I will turn it over to Ian to go over our agenda and get us started.
All right, good morning, everyone. My name is Ian Rambarran. I am chair of the Legal Issues Committee for the CMBA. Today we have a great presentation for you. We've got the experts in the field in servicing and lending law, but particularly we have been able to convince them to refine their analysis and contribute in a way that I think is completely relevant to what we do today. There's a lot of legislation happening at both the local, state, and federal level, but today we're primarily going to focus on the federal level. And we have an update too from Susan Milazzo, our CEO of the CMBA, who's going to give us a legislative update at the state level. Times are changing; they're moving quickly. It seems that it's only been, in reality, it's only been about 7 or 8 weeks since we all locked down and were ordered to shelter in place. But there's been a series of pieces of legislation, orders that have affected our ability to practice, our ability to service loans, our clients' ability to service loans, and created uncertainty. So today I'm very, very happy to bring the presentation to you, because we have, like I said, experts in this area. We have Susan, as I mentioned, and then Michael Flynn of Buchalter, Niemer, and then Jarlath Curran from Severson and Werson, and Rich Andreano from Ballard, Spahr. And as you can see from the agenda, we're just going to knock it out 1 through 4 pretty efficiently. I will start basically on the latest in the COVID executive orders. There have been none since March 2017 as it relates to Governor Newsom's orders, but those orders have had a pretty limiting effect, as you all know, and the CMBA published a series of articles on its websites and member alerts on this point. But pretty much Governor Newsom restricted the ability for the sheriffs to work in the unlawful detainer arena, as well as expanded timelines in which people who were affected by the COVID issues had to deal with unlawful detainer responsive pleadings. And the Judicial Council actually expanded on Governor Newsom's order and severely limited what it is that any sort of landlord, whether it be REO landlord through lenders and services or landlord in general, could do with regard to filing new actions. And it's pretty much said that the courts are restricted from issuing new summonses and complaints. The courts are restricted from taking any sorts of defaults. The courts are restricted from moving to trial on any issues regarding defaults as it relates to unlawful detainer matters. And we're going to get into the CARES Act in a significant way throughout the presentation, but the CARES Act, as it relates to unlawful detainers, has restricted the any loans that are federally backed or any properties that are federally backed from moving towards the unlawful detainer process for at least 120 days. So this is a huge pause in the ability to collect on collateral and put it back in the market. Whether it's wise or not is, debatable. And there's a whole lot of talk on, what is necessary for the public health. The orders are out there, they say what they say, but I will note that a class action was just filed this week on behalf of all landlords because they felt overly restricted by both the Judicial Council restrictions as well as Governor Newsom's restrictions. And the class action essentially said that it's shifted the risk all back to the landlords and was an unfair taking. We'll see what happens because these are just temporary orders, but the impact is going to be quite significant. However, there's that's going to have quite a long life of its own, and we'll just have to see what happens. Hopefully, we can find a good balance to keep everybody safe and keep everybody generating income as is very much needed right now. And with that, I will pass it on to Susan.
Great. Thank you all. I appreciate that. I think I've got control now. So today, Dustin asked me to share with you kind of an update, what's happening on the legislative front in the California State Legislature. Just briefly, the legislature itself was in an unscheduled recess due to COVID-19 for many, many weeks. As all of you likely know, that is unprecedented in the state of California. We are a very full-time legislature and are in on a regular basis. So they were supposed to reconvene back in April. That got delayed until May 4th, and so the State Assembly reconvened on the 4th. What that's going to do for the balance of this year are a few things. One, there's a much tighter timeline under which we're working, right? There's a shorter window of time to get a lot of work done. Legislative leadership has asked members to reduce the number of bills that they're going to be pushing through the legislature this year in order to prioritize those measures that specifically relate to COVID-19 impact on Californians. The other element that kind of leads into the first topic that I'm going to talk about has to do with our state budget. Earlier this year, it was announced that the California Department of Business Oversight, which is of course our main state regulator here in California for residential lenders, was going to reorganize and rename and expand their capabilities within enforcement realm in the real estate finance industry. They were going to be rebranded as the Department of Financial Protection and Innovation. And we had very, kind of just really broad brush information about how that was going to move forward this year. Instead of making it a piece of legislation, there's actually a series of trailer bills which are attached to our state budget that we're going to implement this change with our state regulator and its scope as far as oversight with the industry. After the pandemic hit, we were kind of unclear as to whether or not that would be continue to be a priority for the administration, and we are to understand now that it remains a priority for the Newsom administration, and we'll be monitoring that as it progresses. Now, they may, typically the way the budget process works, we have a May revise that just came out, and we have to pass a budget by June. Because of the impact of COVID-19 and our state and revenues being received over the summer, there's going to be a August budget revise as well. So what that means is that if this series of trailer bills is not included in the budget that passes in June, there is still an opportunity for it to happen in August. And again, at this point, we don't have a lot of robust details on what exactly the new scope will be for the department, but it will be, once it is implemented, it could be a major change here in California, and it's something that, as it evolves, we'll certainly be following that and keeping everybody up to date. But just because it doesn't happen in June doesn't mean that it's not going to happen at some point in August. Dustin, I don't know that I've got the. It does show that I have the ability to move them, but I can't seem to advance that slide. Could you push to the next slide, please? Thank you. So then I wanted to pick out just a couple of bills to talk about, and there are two that we have been very, very active on. The first is AB 828 by Assemblymember King out of the Bay Area. And kind of relating to how Ian had started the webinars talking about unlawful detainers, but this bill has implications on both the residential and kind of the multifamily side of the industry. The residential side, the bill says you cannot begin a foreclosure on a residential property during the COVID-19 state of emergency, and courts cannot accept any foreclosure action until 15 days after the state of emergency, which, as we all know, is an open date on the calendar at this point. And certainly something, the language of the bill does leave a lot of ambiguity as to how servicers will be able to continue even after the pandemic. On the tenant eviction side, once a landlord is able to go to courts with an unlawful detainer, it could direct those courts to reduce that tenant's rent by 25% for 12 months if the borrower demonstrates they've had either a decrease in income or an increase in household expenses due to COVID-19. I think the parameters of the bill, I think any of us could make a case that we've all been impacted by COVID-19. I think that even if you're working at home and collecting your regular paycheck, you can say that I've had increased costs because I'm at home more and using more, data, electricity, or what have you. And the fact that it is, again, kind of, making the landlords, bear the brunt of the impact of COVID-19 is something that is very problematic for us. We have provided the author with a summary of kind of the borrower relief efforts that are available at the federal level, as well as we have a very strong opposition letter. We've joined with several other associations, including the National MBA, to oppose this measure. It's in the second house, it's in the Senate Assembly bill, it's in Senate Public Safety, so it's not going to be heard right away, but it will be scheduled to be in committee here in the coming weeks. So that is a bill that we are certainly following closely. Our next bill is AB 2501. Thank you. Sorry about that, not being able to advance that. It's introduced just this week. As a matter of fact, we kind of got a notice on late Friday afternoon that this was going to be introduced. It's AB 2501 by Assemblymember Limon, who is chair of our Assembly Banking Committee. It's kind of an omnibus bill that covers multiple sectors of the financial services industry, but I will share with you some of the mortgage-related provisions. It allows for forbearance with really no proof of COVID-19 impact for at least a year after the emergency has passed. So there's an automatic, if a borrower is 60 days delinquent, it is this bill, if enacted as it currently is currently worded, would give you 180 days of automatic forbearance with an automatic renewal of another 180 days. Obviously incredibly problematic for the industry. Servicer can't take any action, assess any penalties or fees during that time, of course. Upon conclusion of forbearance, the servicer would have to determine the borrower's ability to repay and engage in some rather robust loan modification remedies that the bill calls for. Among the more problematic elements of the bill, if the server violates any provisions of this measure, they forfeit the ability to foreclose forever. On the multifamily side, the language does provide for a commercial servicer to be in compliance if that commercial servicer is in compliance with the CARES Act. That's just kind of a very short summary of an incredibly problematic piece of legislation. We are in a very tight timeline to respond on this. It is going to be heard next Tuesday on May 19th, and we are working with the National MBA as well as our partners in the financial services industry, and we are in real time developing a rather robust opposition letter. We're gathering information and data to provide to the author. Again, robust efforts for borrower relief that are available at the federal level already, and how this type of measure could be very, very detrimental to our housing market here in California. We're also engaging some of the federal regulators and trying to get their attention to this. As you all know, the GSEs own a significant portion of the loans in California, and so this is of critical interest to them as well. We will be, providing updates on legislation through our weekly videos and on our website and through our webinars. So if anybody has any questions on a particular piece of legislation, you're certainly welcome to contact us here at the California MBA, and we'd be happy to provide you any updates that we have. And that's it for the update today.
All right, thank you, Susan. On to Mr. Michael Flynn.
Well, thank you. I'm going to briefly talk about some of the programs the Small Business Administration is offering as a response to the COVID crisis that may be of interest to members of this organization and people and clients of yours if you're an attorney. I'm going to focus on two things. One is the PPP, the Payroll Protection Plan, which has been getting a lot of publicity, and the second is the soon to be launched Main Street lending program offered by the Federal Reserve, initially funded by Treasury. There have been some other programs. There initially was a program called the Economic Injury Disaster Loans Program, which was the very first one SBA launched. It has run out of money. There's been so much interest in it, except unless you're an agricultural business, it's not available to you right now. So we're not going to talk about that. Let's talk instead about first about the PPP, the Payroll Protection Plan program. As background, that program provides that if you are an eligible borrower, and an eligible borrower would be someone who, an entity that has 500 or fewer employees in the U.S., or meets other size criteria, such as tangible net worth of less than $15 million and less than $5 million revenue on average in the last 2 years, can qualify for these loans if they can show that they need the loans, and they have to certify that they need the loans because of the economic uncertainty created by the coronavirus. And we'll talk about what's happened with that requirement. It's caused a lot of issues recently. I should point out that there are SBA affiliate rules that apply here, so that if your company has fewer than 500 employees, but the people or other companies that control you, and there's several definitions of control that SBA applies, or have effective majority ownership control, or have certain aligned economic interests, then you have to count all those affiliates. So that, let's say you are owned by an entity that also owns a completely separate line of business that has 2 or 3 entities that do some other kind of business. If it owns all of you, you have to count all those entities together to see if you get to 500. So this loan does have some limitations. It was first launched with $350 billion. It was extremely popular. That money ran out very quickly in less than 2 weeks. Congress then added another $300 billion, but because of the problems I'm about to talk about, that in the last couple of weeks has only been about half subscribed. There's still about $150 billion left. And a lot of people have gotten nervous and don't want to take the loans, although something happened yesterday with some announcements from Treasury that may open the doors again. So let's talk about the problem that this program had that had people concerned. The main problem was, and you can see the question on the screen, this is one of the SBA's and Treasury's frequently asked questions that they keep modifying. They now have over 46 of these that are posted on their webpage. This has to do with the certification requirement And it was very, there wasn't much definition of what was meant by economic uncertainty in either the CARES Act or the initial interim final rule published by Treasury. So this was a follow-up question that Treasury and SBA presented. Do businesses owned by large companies with adequate sources of liquidity to support the business ongoing operations qualify for a PPP loan? And we have attached as one of the handouts here, a handout called FAQ PDF. And that is that as of a couple of days ago were the current Treasury FAQs on this bill. And what Treasury said in regard, hold on a second, let me get control here. There we go. What Treasury said in response to that question was that if you're a large entity, Treasury is going to, if you not a large entity, but if you take a large loan over $2 million, Treasury is going to review your loan to see if, in fact, you had sufficient economic uncertainty and lack of access to other available credit. And if so, you're going to be in violation of the program. It wasn't defined what the penalties would be for that. It wasn't defined what was meant by other available credit. It wasn't defined if the other available credit, what level of impact using the other credit would have on the ability to get credit in the future or on their operational requirements. None of those things are very well defined. This caused a lot of companies to get very concerned. So Treasury said, if you return the funds if you have a loan of over $2 million and you return the funds initially by May 7th, then they changed it today, May 14th, no questions asked. We won't look to see whether you certified in good faith or not. This caused some companies to return the money. This has caused a lot of other companies to not take loans right now because of their concerns about this. And then yesterday, in a kind of strange timing, Treasury issued an FAQ to further clarify this issue and to try to make people not be as concerned about it. And what they said in that FAQ was two things. First, for loans over $2 million, they said that that those loans will be reviewed by Treasury. If Treasury finds problem with SBA, and if they find problems with the certifications and notify you of that down the road, and you then simply return the money immediately, they will not look any further into the question of whether you acted in good faith with your certification. They will not initiate any administrative proceedings, and they will not refer the loan to other federal agencies, including Justice, for further action. So that would seem to indicate that if you took one of these loans and it turned out that you didn't have quite the economic uncertainty you might have thought was coming, or the economic uncertainty didn't develop, and Treasury calls you on that, questions you on that, you can simply return the loan, and there won't be any need to then argue with Treasury about whether or not you were acting in good faith when you made the certification. I think that's obviously a big relief to a lot of companies. The second thing Treasury said yesterday was that if you have a loan of less than $2 million, it is a safe harbor. You will be deemed to have made this certification of economic uncertainty and need in good faith. And their justification for that was that, number one, the rules were somewhat vaguely written. This was rolled out very quickly. People didn't quite know what they were certifying to. Secondly, these smaller businesses probably, who are taking smaller loans, probably on the whole have less access to other credit, so it's not as big an issue. And so and thirdly, they want to preserve SBA and Treasury resources, review resources for more serious issues, and therefore they're providing safe harbor. That is, I can tell you that already many companies have seen this as a big relief, and a decision maker for some companies who were waiting till the last minute to decide whether to take one of these loans for today's deadline for returning money have decided to go forward because the safe harbor appears to give them what they might think is adequate protection. That is the biggest issue regarding this PPP program, but it's not the only one. There is also the question of, as people start using these loans, they have to use them in an 8-week period from when the loan was funded, and they have to use it on essentially 4 defined allowed uses: payroll costs, rent, mortgage interest payments if you own the building in your facility, and utilities. The forgiveness rule in the CARES Act said that to get loan forgiveness after the 8 weeks, they will only forgive loans. They only forgive a dollar amount so that 75% of what you're asking to be forgiven was payroll costs. The idea being, if they wanted to try to make sure that the purpose of the act, which is largely to preserve jobs, is followed through by saying, we'll forgive this loan. You don't have to repay it. If you submit for forgiveness, the portion of your loan where 75% of it was spent on payroll. The question that developed was, what happens if you, for the entire loan, you spend less than 75% on payroll? And that's not exactly clearly defined. If you look at this Q&A answer that Treasury posted that's on the screen right now, there is a in talking about this issue, they do say not more than 25% of the loan forgiveness amount may be attributed to non-payroll costs. People were not quite sure if that sentence meant that they were talking about forgivable costs, expenses, or all loan proceeds. But and Treasury hasn't really clarified that, but given that language, there's certainly an argument that what they're saying is that irrespective of how much you ask for forgiveness, the whole loan package, all the proceeds you receive, at least 75% must be spent on payroll costs. That would actually be logical and consistent with the purpose of the Act. The Act itself doesn't say that, but Treasury was authorized in the CARES Act to create implementing regulations and rules, and this is what they said. However, this issue does remain. It's not quite clarified, and we may see further guidance. Treasury has promised forgiveness guidance because we're getting into the period when people are actually spending money on these loans, and in a few weeks, the first recipients are going to start submitting to their lenders requests for loan forgiveness under this program, and the question will develop as to exactly what some of these nuances are. So there's going to be further developments in that regard. There is another program that allows larger companies to get funding, to get loans. Those loans, however, are not forgivable. This is the Main Street Lending Program, which consists of 3 separate Main Street lending loan facilities set up by the Fed, wherein lenders will have to keep a small portion of the loans they make in this program, somewhere between 5 and 15%, depending upon which of the 3 facilities are accessed. And the lender retains the remaining 95 or 85%, or not, excuse me, the lender sells the remaining 95 or 85% to this Federal Reserve special purpose vehicle credit facility that is set up. So it's a participation system where the lender keeps a very small percentage and the Treasury or the Federal Reserve through this vehicle takes on by far the largest ownership. The loans will be 4-year loans. The adjustable interest rate of either the 1 or 3 month LIBOR index plus 300 basis points. Interesting, they used LIBOR because, of course, everyone's trying to move away from LIBOR, but they felt that the new SOFR index just isn't developed enough yet to put this massive program, which they expect will go up to $600 billion of lending, into the SOFR index yet. So the lender's required to use the LIBOR index plus 300 basis points and use the fallback waterfall language that has been developed for transition from LIBOR down the road. The loans themselves are at amounts of from $500,000 up to $200 million, depending upon which facility you use. So these can be very large loans, and they're available to companies that have 15,000 or fewer employees, or 5 billion, or not and, but or 5 billion or less of annual revenue. So if you meet either of those criteria, you are in fact, an eligible borrower. If you look at one of the handouts we had was my firm's Buchalter COVID alert about this program. And in there, we cited the old threshold, which was 10,000 employees and 2.5 billion of annual revenue. That has now gone up. It's 15,000 employees or 5 billion of annual revenue. Some key things about this loan is that there's some language in there about how the loans, that any prior debt you have must be pari passu with these loans. It's not explained how that's to work. These loans can be secured or not secured. And along with new loans, you can also extend current credit facilities you have. That's the largest of the programs. It allows you to go up to 200 million. And again, if there is security on the present credit facility, you have to expand. You have to securitize the extension as well. The other issue I want to point out is that these loans are not, this is not a double dipping problem. You can have a PPP loan and then apply for these loans. So it's possible that if you already got a PPP loan and it turns out it's not enough to see your company through the crisis, you can apply for one of these. But as I said, unlike PPP, there's no capacity for forgiveness for these loans. You would have to pay the interest. If you get what's called a Main Street new loan, which is up to I believe $25 million, you repay that at the end of the second year. There's a 1 year deferral of interest and principal. So at the end of the second year, you would pay 1/3 of the loan. Third year, 1/3 of the loan. At the fourth, the remaining 1/3. For the other two types of loan facilities that are involved here, you would pay a smaller amount. I believe it's 15%. Second year, the first year you pay anything, and then the remainder in equal amounts the remaining 2 years. This program has not yet been launched. Treasury has announced it will fund $75 billion into these credit facilities, which will enable the Fed to leverage them up to about $600 billion of available credit. However, the Fed has issued detailed term sheets. If you look on the COVID alert from my firm, you will see links to those for the 3 different credit facilities. They're fairly detailed term sheets already, but the program hasn't been launched. The special purpose vehicle has not been opened up. If you're interested in this kind of program, though, I would suggest you start talking with your lender right now. Available lenders are essentially any federally regulated or insured bank or holding company, and any holding company or subsidiary of a foreign banking entity that has branches in the U.S. So basically, any bank right now, they are not allowing other types of financial institutions into this program, but they're thinking about it. But right now, if you're interested, I recommend you go talk to your bank and see what you need to put together to the extent the bank itself has already started creating its own requirements for the program, and then be prepared to move as soon as these credit facilities are open and the banks feel they're in a position to start making these loans. I'd be glad later to answer any further questions. These are pretty complicated programs, but I don't want to bury you with too much minutia. Let's move on to Jar for the next segment of the program.
Okay, great, thank you. Let me just see, I've got, Justin, I don't seem to have access to the PowerPoint yet.
Yep, you have control of it now, Jar. Yep, there you go.
Okay, great, thank you very much. Thank you. So what I'm going to chat about today with respect to the CARES Act is the mortgage forbearance plan authorized under the CARES Act. Some of the general topics we'll be discussing. First, what it allows with respect to the forbearance plans, requirements to qualify, what the borrower needs to show, what happens at the end of the forbearance, which I think is really where the rubber hits the road in this aspect of it. How servicers are handling the non-federally backed mortgages, since the CARES Act only applies to the federally backed mortgages, such as Fannie and Freddie, FHA, VA. Potential litigation that we think is going to happen down the line, and then just some tips to mitigate that risk, to avoid litigation as much as possible. So what the Act allows, so for all borrowers with a federally backed mortgage, they can request a forbearance. It's 6 months, 180 days off the top, and the servicer is required to start reaching out to the borrower 30 days or more before that forbearance plan ends, and the borrower has the option to extend that additional 6 months. So we're talking a year of forbearance. If the borrower wants to terminate, he or she can upon their request, and there's also no prohibition from a borrower actually making a payment on the loan during the forbearance plan if they can or choose to do so. It applies to first and second mortgages for 1 to 4 unit family homes, and again, just only applies to the federally backed mortgages. Requirements to qualify, not that much. First thing, a borrower has to ask for it. A request needs to be made. And the borrower needs to affirm that they're experiencing a financial hardship caused by the COVID emergency. hardship is due directly or indirectly to the emergency, and all they need to do is just attest to the hardship. There's no other qualifications. There's no documents. The amount of the loan's delinquency is not an issue. So if it was already in default before the COVID issue arose, that is not a problem in terms of getting the forbearance agreement in place. As I mentioned before, what happens at the end of the forbearance is going to be interesting. Housing Wire had an article today mentioning that nearly 4 million borrowers are in forbearance at this time, which is a lot of borrowers. There was a prior article, I think earlier in the month, that said before all this occurred, the percentage of borrowers in a forbearance was 0.25%. So 1/4 of borrowers were in a forbearance before the COVID emergency came around. Now it's at 7.5%. And I'm guessing that's not going to slow down. So we're going from 1/4 to 7.5%, and it could keep rising to 10%. So 10% of loans are going to be in a forbearance at some point, possibly, which is a high amount. And you know, the payments that are being forbeared, they're not going away. The borrower is going to have to pay these back in some way, shape, or form. So the slide up now is sort of generally what the options are that have been discussed or at least available. The lump sum payment, you know, it's not practical, I think. If we're at 12 months of a borrower not making a payment, they're not going to be able to pay a lump sum to cover those 12 months. There was a lot of confusion about that early on, but I know Fannie and Freddie have been pretty clear. They had a news release from late last month that they're not going to require this option, and that they're encouraging the non-GSE loans to also not require the lump sum. It is an option on the table, but it's not going to be pushed, I think, and it's not going to be required by the GSEs. The repayment plan, I mean, it's not as impractical as a lump sum payment, but still pretty difficult. This would take whatever the forbeared amount was, the 6 months or the 12 months, and have the borrower repay that amount over some period of time. But if the borrower can't make the regular payment, it seems very unlikely they can make that regular payment plus an additional amount to cover the forbeared amount. So also an option, but probably not very practical in a vast majority of situations. The loan modification is really where the borrowers are probably going to be focusing on. The types of modifications available will depend on Fannie or Freddie, whatever GSE is backing the loan, whatever federal agency is backing the loan. In this realm, I think the main focus or the most beneficial option for the borrower will be the payment deferral solution, which will basically take the deferred amount, or the forbeared amount, and put it on the back end of the loan. It wouldn't accrue any interest, so the borrower would have to pay that deferred amount when it sells the property or refinances the loan, but they'll just basically take that chunk of money that was forbeared and put it on the back end. One important thing to note about this is to qualify it. Look, the borrower is going to have to be able to make the regular monthly payment. So hopefully that's the case in most instances. You know, it's sort of a temporary issue here with COVID, and these borrowers are back on their feet, are able to make the regularly scheduled payment pursuant to loan terms, and then the forbeared amount just gets kicked on the back end. Of course, short sale and deed in lieu are there as well, but you know, most borrowers are not interested in something like that. They want to keep their home, so it is there, but probably not going to be a big option available or pursued by the borrowers. A distinction here for what happens at the end is that, in contrast to forbearance, is they will need to submit some financials, do a modification review, a foreclosure alternative review, in order to see what options are available. And again, what types of modifications are there, or the types of repayment plans are available, will depend on what government, Fannie or Freddie or FHA, whoever is backing the loan. So handling non-federally backed mortgages. So as I mentioned before, CARES Act only applies to the federally backed mortgages. So private loans, non-GSE loans aren't subject to it. What I've seen or kind of heard is servicers are giving these forbearances. Usually it's 90 days, and they kind of see what options are available after that 90-day period. They'll attempt to contact the borrower, discuss options. One of the distinctions here I've seen is the delinquency does matter. So the default needs to be within 30 to 60 days of when the request was made, so it has to be the result of the COVID emergency. If they've been delinquent for the last 12 months, this forbearance option is not going to be available for the non-GSE loans. When the forbearance plan ends, are trying at least to get deferral programs. They prefer to have that. A lot of it depends on the investor guidelines. So the modification options, the deferral programs available are kind of limited, I'm sure, in instances based on what the investor is allowing. But in terms of the state-specific foreclosure moratoriums or state-specific laws, I think they're using that to give them some leverage with these private investors. Susan mentioned earlier AB 2501, so that is basically mirroring what the CARES Act is doing in California, although it has some more restrictive aspects to it. But in terms of these private loans or non-GSE loans, since they're not subject to CARES Act and the investors technically don't have to follow it, they're using these state-specific rules and moratoriums and orders to give them that leverage to assist the borrowers as much as they possibly can with these non-GSE loans. So potential litigation, that is, we'll see down the line. The first is federally backed versus the private. So here it's basically borrowers may not understand the distinction. They may not understand why their neighbor got the 12-month forbearance deferred to the back end of the loan, and they don't have that option, and may sue claiming they're entitled to that option. We saw something similar to this when HAMP was rolled out all those years ago. Lawsuits were filed not understanding why they couldn't get a HAMP loan, which was typically the best option they had or best terms they can get, and it was because their owner of their loan didn't participate in HAMP. So it wasn't an option available, but that was not a distinction that they knew about or totally understood. So litigation will be on that, just not understanding the distinctions between the two. The second bullet point of inability to obtain relief due to backlog, and the last one, mistakes due to sheer volume of requests. I mean, there's just so many forbearances in play, so many borrowers affected, the sheer volume of what's going on. Mistakes are going to be made. It is what it is, I think. So borrowers will claim they were entitled to relief, but they didn't get it in a timely fashion, and it caused them damages. So that's probably going to be happening quite a bit. Possibly not with the forbearance aspect of it, but once the forbearance plan ends and they're looking for some more permanent loss mitigation, such as the mortgage modification, things like that, I think that will be where these issues arise. And finally, the CARES Act interplay with state loss mitigation laws for California, the Homeowners Bill of Rights. Potential issues there are, what part of the Bill of Rights protections come in play with the forbearance? I mean, is a borrower calling in and saying that they have a financial hardship due to COVID? Is that a complete loan modification application? Does that entitle them to a single point of contact? So those are questions that are out there and it may not be answered. The practical effect of that I may be minimal, I think, given that services are pretty well equipped and are usually allowing the protections of the Bill of Rights to come into play pretty quickly. So hopefully it wouldn't be an issue down the line, but it could be. Let's see, my last slide. So tips to mitigate damages. really it's just common sense, adhere to best practices developed in the wake of the Great Recession. So, I mean, the servicers were really caught off guard in the Great Recession in dealing with just the volume of people needing loss mitigation assistance. But now they've already had that sort of foundation in place. So keeping up with those developed practices will help moving forward with the forbearances and dealing with the COVID crisis. Clear communication with borrowers as best as they can. Explaining the distinctions between what's available for a GSE loan and what's available for the borrower's loan if it's a non-GSE loan. Good communication will help to prevent confusion later and lawsuits later. Prompt communication with foreclosure trustees and preservation vendors. We don't want a borrower receiving a default foreclosure notice while they're in a forbearance plan, things like that. So need to have the stops on that type of activity. And then sufficient staffing. We've got 4 million borrowers in forbearance plans. We're going to have 4 million borrowers in loss mitigation review at some point in the next 6 to 12 months. So the staffing needs to be there to handle that kind of volume. So it decreases the number of mistakes and hopefully avoids litigation in the future. So thank you. That's all from me. I'll pass it off to Rich.
Thank you and good day, everyone. What we're going to do is look at some of the provisions from CARES Act, some things that are happening now, and then some things that may happen in the future. And doesn't look like I have control yet. Oh, there we go. And yes, here, CARES Act. Now, there's a credit reporting provision. And I've gotten a lot of confusion on this where people were wondering, is it really the same in scope as the forbearance provisions? And actually, it's different. It's an amendment to the Fair Credit Reporting Act, actually, and it's not limited to CARES Act forbearance loans. It's not limited to mortgage loans. It really applies to anything covered by the Fair Credit Reporting Act. So it's quite broad. And the two key concepts are an accommodation and that accommodation occurs during the covered period. The accommodation basically refers to an agreement either to defer, modify, forbear, basically allow the borrower to do something less than required by the credit instrument. That is an accommodation, so fairly broad. Now, what I found with this provision and a lot of other provisions that have been adopted quickly is people are starting to engage in hyper-technical interpretations of them. And what I like to remind people is governments, agencies, and legislatures are not the best drafters often under ordinary circumstances. When they draft quickly, the drafting is even worse. So let's not engage in hyper-technical readings. Let's understand the intent. And some people are looking at the word agreement and accommodation and saying, well, with the CARES Act forbearance, the servicers not really agreeing, they're forced to do it. So is that really an accommodation? Let me make perfectly clear, don't go there. Congress intended this to apply to a CARES Act forbearance. Fannie, Freddie, FHA, VA, and USDA have all made clear it applies to a CARES Act forbearance. So a CARES Act forbearance is an accommodation. Now, the covered period, it actually started back in January 31, rather, and we'll go to the later of, assuming this isn't changed, and we have to assume all of this is subject to change in further legislation. It was a later of 120 days after March 27th. That was the date the CARES Act became law, or 120 days after the date that the national emergency terminates. Susan indicated before, that's an unknown date. We don't know when that's going to occur, but that's the operative provision now, and expect that that might well be changed in the future. Now, what the reporting requirement basically is, what it really does is when you have an accommodation, you're basically freezing the loan in time. So if the account was current at the time the consumer came in and asked for the forbearance, then you continue to report it as a current loan, even though they may miss up to 12 payments. It is still reported as current. Conversely, putting aside charge-off accounts, if it was delinquent, let's say it was 30 days delinquent at the time the borrower came in and made the request, you freeze in time the 30-day delinquency. That's what you report. The fact that they could have up to 12 more months of delinquencies doesn't count. You keep reporting what in fact the loan was at the time of the forbearance. Now, if miraculously they were to bring the loan current, you would then report the loan as current, but we expect that that will probably be few and far between in terms of that ability. Now, what might happen? There's been a lot of talk of further stimulus legislation, and there have been a lot of proposals that have been kicking around, particularly on the Democratic side in the House. And one, there was pretty early on the recognition that while the CARES Act applies to a number of loans, the federally backed loans, it also excludes a number of loans. And the thought is that probably this needs to be more universal. One, doesn't matter if you have a federally backed loan or not. If you're facing difficulty because of COVID-19, you're facing difficulty. So the thought is to extend that to all loans. It also helps eliminate the confusion of why the guy across the street get it and I don't get it. The foreclosure and eviction moratorium, the thought that that would be extended beyond federally backed mortgage loans. We also have the issue of how long it lasts. The legislation we have now under the CARES Act is a minimum of 60 days from March 18th. We're coming up to that. However, earlier today, Fannie and Freddie just put out revised guidance extending their foreclosure moratorium to June 30th. I expect we'll see the same from FHA, probably VA and USDA as well. Looks like June 30th may be the new magical date for that. The other thing they did at development, it happened late yesterday, they issued it. Fannie and Freddie both issued specific COVID-19 payment deferral programs. What it would do was would take up to the 12 months of payment that were missed, plus escrow advances, and a few similar items, put it together in a non-interest bearing account essentially that would then be tacked on at the end and payable when the loan pays off, the property is transferred. So that will be kicking in on July 1, development there. Now, what else? The lump sum payment. Congress pretty quickly started hearing the rumors of, well, the CARES Act doesn't prohibit a lump sum payment, and servicers were suggesting that would be required. Well, future legislation, the thought is they'll make that clear, but in the interim, Fannie, Freddie, FHA, and VA all jumped in, as well as FHFA, and said, no, lump sum payments will not be required for these, but that may actually wind its way into legislation itself. Then we also heard they were, had gotten to the Hill that, gee, the GSE patch is expiring in January of 2021. So they were thinking of bumping that sunset out a year. But what they were also going to do is freeze federal rulemaking unrelated to COVID-19. I was talking with a number of people. I said, that's actually a bad idea, because if you only bump it out a year and then you don't let CFPB work to develop by rulemaking the replacement to the patch and the current very strict 43% standard QM, we could have the patch then expire in January 2022 without any replacement. That would be a bad thing. So the thought there is what we need to do, while support an extension of the sunset, tie that to the implementation of whatever the replacement is. In fact, the National MBA, in their comments on the advance notice of proposed rulemaking in this area, suggested that the sunset be 1 year after the publication of the final rule that would be the replacement. The thinking there is it'll probably be a year implementation period. So there's some lobbying efforts along those lines. What we also have to see, though, in this area is the Bureau had targeted this month for the issuance of proposals on the ability to repay, which were going to be an extension of the sunset and whatever the replacement will be. We're not exactly sure what that will look like. They were a little late on getting the HMDA rule out. It had been targeted for March. They got it out mid-April. Obviously, they've staffing issues like everyone, plus they're doing a lot of COVID-19 issuances. So whether they make that May timeframe or not, or whether Congress goes first or they go first, these are things we're just going to have to see, but watch for developments in this area. Now, one other thing that was very big, as we're talking more and more about the advances, is the obligation on servicers, particularly the non-bank servicers that have credit lines and some capital, but they're not banks. There is an end to how much advance facility they have. So the industry initially started making some sounds that, look, forbearance is the right thing to do. Absolutely, we agree with that. But, and the but is for non-bank servicers, we need some help. And both American bankers and mortgage bankers were joining in on that. It was really a joint industry request. that made its way, to FHFA, and Director Mark Calabria was interviewed. And apparently the comments there were, well, I don't think the level of forbearances will get as high as folks are predicting. And if servicers do have some trouble, we're not going to provide a facility. We'll just pull the servicing from them and move it to another servicer. Well, that was not well received. What I compared it to, might recall, those who have been around a little longer, in the 70s, New York City was running into quite a fiscal difficulty, and it was floated, does the federal government bail out New York City? And President Ford quickly put the kibosh on that. And so the Daily News headline, no one ever accusing the Daily News of being subtle, was Ford to New York, drop dead. And I heard a lot of people saying, Calabria to mortgage servicers, drop dead. Pretty good analogy if that was the case. But we actually did see some action. Ginnie Mae stepped in with an all participants memorandum. And what they do is they created a facility, a pass-through assistance program, and you have to apply for it at different dates monthly to get advances. They expect this to be a resort of last use. If you have anything else, they expect you to use that before you use this. But then as the delinquency started rising, FHFA actually did step in, and it limited the Fannie Mae advance obligation to be more consistent with the Freddie Mac 4-month period. So they cut that off at 4 months. Fannie has come out with some initial guidance saying, we're working to implement this, a lot of things we got to do to implement it. It will kick in for the August 2020 remittance based on July 2020 reporting activity. Exactly how we're going to do it, stay tuned, we'll be back to you. So we have that. But what the industry did also is clearly started pivoting to Congress to get Congress to support pushing the federal government to provide a facility. So far, Treasury Secretary Mnuchin is a little lukewarm, but saying, let's see what happens. We now have a lot of letters of Congress, both House, Senate, Republican, Democrat, all supporting this. Interesting thing, a letter by House Democrats, most of them members of the House Financial Services Committee, so obviously a little more important, sent in a letter supporting it. But what they also said is, we need to develop uniform loss mitigation options, and you're seeing Fannie and Freddie doing that now. And you should also condition access to the facility, and remember, this is in the context of a third-party servicer. You should condition access on the servicer agreeing to extend forbearances to all borrowers. Obviously, if you're a third-party servicer, you're servicing for someone else. You cannot agree to an extend of forbearance on your own. Congress can force that, but that would have to be fixed if that's the approach they try to go with. Again, stay tuned on that. Now, as Jarlath mentioned, forbearances going up. They were about 7.4% the week before May 3rd. Now, as of May 3rd, about 7.91%, which is about 4 million loans. And remember, May 3rd, people are staring at the May payments now. That number is going to jump yet again. My thought is once we hit 10%, that becomes a psychological and politically significant number. You might see movement at that point. And what you might see, again, from the MBA and then with the great support of the California MBA, is a call to action on the Mortgage Action Alliance when you're asked to help lobby your legislators to support a facility for the industry. So that'll be very important to have our voices heard. With that, I turn it back to Ian to close us out.
Okay, thanks, Rich. And I think everybody did a great job here. And to follow up on Rich's points, Fannie Mae just updated its lender letter today. So they summarize what it is that they're looking for in a semi-plain to read format. So you should check that out. And with that, I'll turn it over to Dustin for any particular questions.
Yeah, I know we're a little short on time here, so that's why I'm putting the contact information up on the screen here. But if you've got a question right now, you can use the questions function. And a quick reminder that we are recording the session, and we'll be posting it on the both the California MBA's YouTube channel as well as the committee website on the California MBA website. So if you've got any questions or want to submit something now, this is the time to do it. I do have one one question here. The question is, can a borrower facing foreclosure seek a forbearance and in effect delay the foreclosure sale? I'm not sure, Jar, if you covered that in your presentation or not, but do you want to take that?
Sure. So I guess the short answer is yes. If the borrower is in a federally backed mortgage, the amount of the delinquency is irrelevant, so they could seek a forbearance as long as they can attest to a hardship that's caused indirectly or directly by the COVID emergency. If it's a non-GSE loan, they may not get a forbearance, at least at this point, since it seems like they're restricting those to borrowers who are only recently in default, and the default is specifically a result of the emergency. But I think we mentioned earlier in the webinar how the California is, there's foreclosure moratoriums, and they also have that pending legislation to kind of mirror what the CARES Act did. So even though in a non-GSE loan, if they submit a forbearance plan, they may not get the plan, but there's no sale going forward in the near future.
Got it. Thanks, Jar. Ian, that's the only other question I've got right now. So I'll toss it to you here. We're just right at noon here, so I'll toss it to you to close this out.
All right. Well, I appreciate the presentation, guys. I thought it was great and is a snapshot of current developments, and those change every single week. And even today, there's an update from Fannie on its website. So we appreciate you guys sharing your expertise and the CMBA for giving us an opportunity to host this. If you have any other questions, then you can submit them to the email address that Dustin just posted on the screen. And with that, we'll close it out. Thank you.